Uh-oh, we cannot hear you, Mark. Mark Salone, we can't hear you. Are you speaking? Oops, there we see you. Can you hear me, Mark Salone? I don't think so. There you go. Mark, can you hear me? Oh, he's not connected yet. There we go.
Okay.
All right, we're ready to roll.
Good morning.
Good morning. Where are we?
We are just starting. So you can open the meeting and then I will do the roll call.
Okay. We're going to call the meeting to order at 9:08. And I believe that everyone has received a copy of the agenda. And I will entertain a motion to adopt the agenda. Is there a motion to adopt?
So moved.
You don't need a motion.
Okay. All right. The agenda will be adopted. You've also received a copy of the minutes. Are there any corrections or additions to be made to the minutes of August 26th? Hearing none, I will entertain a motion to adopt the minutes.
So moved.
Second,
Second.
moved and second, all in favor, say yay.
Chairman, we need a roll call.
Oh, yes,
So-
I'm sorry. Thank you, Ms. Saltmarsh, please.
The roll call vote will also serve as attendance for this meeting. So
Yes.
let's see. Kelly Cassidy. I think she just joined, may not be. There she
Present.
is. We're voting on the minutes and doing roll call all at once.
Great,
So,
thank you. So present and I.
all right. Ryan Spain. Did not see him join. Darren Bailey. I got an email from Bob Berlin that he is at a funeral this morning, so he will not be joining us. Ray Jones.
Aye.
Scott Main.
Zen and I.
Jerome Mitchell.
Aye.
Toya Hughes.
Present and I.
Toby Cates.
Present and I.
Yakov Delaney is represented today by Orlando Mayorga. Orlando.
Aye.
Mitchell Davis.
Yes.
Shoba Mahadev.
Present and I.
Marcus Salone.
Aye.
Cheryl Ingram.
Here. Aye.
And I got an email this morning with sad news that Steve Sawyer, who has not been able to attend our meetings, cannot be with us today and is also resigning from the task force. So I think the only thing to do with that is to inform the Lieutenant Governor's office, since SPAC operates under her umbrella, that this has occurred. But at this late date, I would not encourage trying to appoint someone to replace him. Sorry that, we will not have his voice. So the motion.
Kathy, my apologies. I did not get asked.
Neither,
Oh, Robert,
neither-
I'm so sorry.
neither did I, Kathy.
Oh, shoot. You know what? I checked you as attending. So Robert on the meeting minutes
Yes.
and Lisa Daniels on the meeting minutes.
Aye.
Okay. Did I miss anyone else? I do apologize. Thank you for letting me know. All right. And then I just want to really quickly remind people of the Zoom processes. First of all, if you wish to speak, members, raise your hand or let us know in the chat. Members of the public, please put questions and an indication that you would like to speak in the chat. If anybody has technical issues during the meeting and needs help, you should email john.specker@illinois.gov. And with that, Chairman Stallone, we have unanimous approval of the minutes.
Very well. I would call on Ms. Lloyd.
Good morning, everyone. I was trying to remember racing lingo because I feel like we're coming into the home stretch. And I was trying to figure out if this is going around the bend or what. But after today, we have a public hearing and 2 more meetings. So there's a lot to accomplish in a relatively short period of time. If you have not had a chance to respond to the invitation for the public hearing, please do. We're hoping that there will be good representation of the task force membership at the public hearing. We'll send the invite again. Today, we're going to focus on the draft recommendations that were also included in your packet. Thanks to Kelly and Robert and Lindsay and Kathy, we have proposed language for a set of recommendations having to do with some substantive issues with respect to resentencing. We're going to consider as many of those recommendations today as we can. Those that we aren't considering today or can't get to today, we'll pick up at the next meeting on September 30th. I want to say a sentence or two about what to expect between now and the conclusion of the task force operations. In addition to the discussion meetings, there will be a final report that will come to you in draft form. Kathy and the SPAC team will be using these discussions. Fortunately, they've been recorded. These discussions, the pre-read materials, the various presentations that have been made to put together the task force report. That will come to you in draft form in November 18th, and we will ask you to provide some feedback and comments at that point. The SPAC team will incorporate all the necessary changes, and then they'll suggest that are suggested by people. The planning team will also take a look at it, so it'll have 2 sets of comments that will get incorporated into the draft. A revised version will then be sent to all of you for final comments. We will have a discussion of the near final report on December 9th. But there will be plenty of time to read through the revised version, which will come to you before the beginning of December. With that, I think we can turn to today's agenda. We are going to read, as we've done in the past, we're going to read through the proposed language and in real time screen share the language so that it can be edited in real time. Another reason why the report can be written, because actually in a funny kind of way, you're actually writing a lot of the report right now. Abigail will make the edits based on the discussion. And with that, I'm going to turn to Kathy or Mark. Kathy.
Hi, guys. I'm just going to give you, with each of our recommendations, just a reminder of kind of points we've covered and information that we've gathered to be, part of your discussions and the basis for the recommendation. The first recommendation that we have falls into we're looking at procedure now. And the first draft recommendation is, Abigail, can you screen share so we can get started with editing? There we go. First, we are going to refresh our memory. In the purple box is the draft language, and below it is an exact copy, but that's the copy that we will be editing so that in the final analysis, you can see where we started and where we ended up. So go on to recommendation number 5. And that reads, the General Assembly shall determine a process by which people serving extreme sentences can petition the court for a resentencing. We started at this point, and at the last meeting, we kind of turned away to a more general approach. But in our initial meetings, and when we heard from our sentencing experts, as well as the experts on trauma, mental health, and substance abuse disorders, we essentially got an overview of how our current state of knowledge has changed. And you will also undoubtedly remember the analysis of the prison population, which we covered in the first meeting. And in terms of actually accomplishing a reduction in the prison population in the near future, we would have to address allowing access to a resentencing process by people who are serving long sentences for violent crimes. In the past, those folks have carved out of our reform efforts. And I would just, I love this from the American Law Institute, which is in the materials that we gave you around the principles. Basically, I think it sums it up. It is unsound to freeze criminal punishments of extraordinary duration into the knowledge base of the past. And finally, we did have one principle that directly addressed this, which was principle number 1, which reads, provide for judicial determination of whether the purposes of sentencing embodied in the Illinois Constitution and the state would be better served by a modified sentence than the individual's completion of the original sentence, based on the current circumstances of the individual and the crime victim, as well as changes in law, policy, and scientific knowledge. So with that, Susan, I'll hand it back to you to get the discussion underway.
Comments? Questions?
Scott, we see your hand.
Scott?
Sure. I guess my comment is because I think we've, the principles or the recommendations we've made so far, we have a recommendation on retroactivity, an eligibility criteria, a procedural criteria. I'm looking at number 5, and I feel like we should draw back in those that we've also that we've declared certain people eligible under number 2, and I want to make sure that we're keeping them eligible under number 5 and not creating any sort of tension point between who we've sort of defined as eligible and to this population. Because I think that obviously I could draw you the Venn diagram in which it's clear that those serving these long sentences would be someone also able to make a showing that their sentence no longer advances the interests of justice. But there's a disconnect that I'm having just seeing this point that doesn't also sort of capture who we've already identified as those being eligible. And maybe I'm on an island with that confusion, so I will happily be told otherwise.
Lisa, watch for hands because.
To refresh memories, the adopted recommendation reads, the General Assembly should establish eligibility criteria for sentence modification, including but not limited to the petitioner serving a sentence for any criminal offense for which the statutory penalty has been subsequently reduced or altered, or the petitioner makes a showing their sentence no longer advances the interest of justice or the promotion of public safety. So Scott, within your point is that we cover the extreme sentences in those 2 criteria.
I think that it's good to be clear. So I like recommendation number 5. I just, since we've sort of highlighted who's eligible up above, and now if we are making a specific recommendation of declaring a process by which people serving extreme sentences can petition, like it, maybe it's just in
Sounds
terms
like
of,
a separate process.
right, where this falls. And maybe this is just 2.5, in which case, you know, we're continuing the same thought. And so I just want to make sure that like whatever process we're creating and recommending here in 5, we've also made sure number 2 is we're creating that same process and eligibility.
Do you have any suggestions on how to? Oh, wait a minute. Cheryl, I saw that comment and I'm going to get back to that in a minute. Do you have any ideas, Scott, on perhaps an addition or language that addresses that concern?
I'm flummoxed.
Clarity that these folks should not be excluded.
I think to my brain, the cleanest way if we're numbering them in the way that we've already numbered them, that here it would be in addition to those found eligible under, in addition to those found eligible under number 2, comma, the General Assembly shall determine a process for by which people serving extreme sentences can petition the court for resentencing.
Susan, you're on mute.
Shoba?
Yeah, I was just going to ask Scott, so that would be a modification just to number 5 to ensure that it tracks number 2. Is that right? What you're
That's
suggesting?
what I'm, yes.
Okay.
So you want to say, in addition to the eligibility factors
Previously outlined.
in recommendation number 2, the General Assembly shall determine. Okay, Abigail. So there you go. Eligibility factors in recommendation number 2. The General Assembly shall determine the process. I think I see your point, Scott, with the shall determine a process. It sounds like we're doing 2 processes. Kelly, I see your hand.
Yeah, I completely agree with Scott's premise. I'm concerned that this wording still has the bifurcation, like the General Assembly is only going to determine a process for the extreme sentences. Like, I feel like we're modifying the wrong part of the sentence.
How about if we just went with something like the General Assembly shall include in the people eligible to motion, those who are, something like that. So it's clear that the recommendation is we do not want this population to be excluded as they have been traditionally in the past, rather than referencing a process.
It isn't the point of it to say that we need to develop a process.
I think the resentencing process is what we are developing for everybody.
Right.
What we want to guard against is the extreme sentences for violent crimes being excluded from that process.
So then we would just say that the General
To
Assembly
include.
shall develop a process by which people may petition for resentencing, not to exclude.
Shobha, did you wanna-
Including the recommendations laid out in whatever number, and not to exclude people serving long sentences or extreme sentences or whatever.
Shobha, did you want to jump in here?
Yeah, I was going to agree with that suggestion. I agree with Rep. Cassidy that we were kind of modifying the wrong thing. My alternate suggestion to that, but I think the one you just suggested, Rep. Cassidy, was fine, was the General Assembly shall determine a process by which individuals eligible under recommendation number 2, as well as or including those serving extreme sentences, and then can
Bingo.
petition the
Thank
court.
you. Perfect. Go for it. That's great.
All right, say that again, Shobha. And
All right, I'm
Abby.
trying to type. Okay. Okay, here it is. The General Assembly shall determine a process by which individuals eligible under recommendation number 2, comma, including those serving extreme sentences, comma, can petition the court for resentencing. I think that captures it, but totally open to people who feel like it doesn't. Editing on the fly.
Comments? Chairman Salone,
Yes.
your thoughts?
I don't have number 2 before me. I will yield to those who do have the second recommendation before them, but I think adding the words to include should suffice.
Someone want to call for a motion?
So moved.
Second.
Okay, it's been moved and second that modified recommendation number 5, which reads as follows. And Miss Kathy, can you read number 5 for us?
The General Assembly shall determine a process by which individuals eligible under recommendation number 2, including those serving extreme sentences, can petition the court for a resentencing.
All those in favor signify by saying aye.
All right, we got to do the roll call because we're virtual.
Yes.
And I should also state that we are virtual pursuant to the disaster proclamation that is still in effect for another few days. So here we go on recommendation number 5. Kelly Cassidy.
Yes.
Robert Peters.
Yes.
Ari Jones.
Yes.
Scott Main.
Yes.
Sharon Mitchell. Oops, Sharon had to leave until 10:30, so He is not here at the moment. Latoya Hughes,
Yes.
Lisa Daniels,
Yes.
Joby Cates,
Yes.
Orlando Mayorga,
Yes.
Mitchell Davis,
I'm gonna abstain.
Shobha Mahadev,
Yes.
Mark Saloon,
Yes.
Cheryl Ingram,
Yes.
okay. We have 11 yeses, 1 abstention, and no nays.
So the motion carries. Can we move on to number 6?
Yes, we can.
Okay,
Number
and
6.
it reads as follows. Any procedure adopted by the General Assembly shall provide adequate notice requirements. The Department of Corrections shall provide notice and adequate materials to inform individuals who are incarcerated of their rights. Comments, please.
I'm going to just jump in really quickly and remind folks that, first of all, notice is obviously embedded in our system to the extent of noticing opposing parties and victims. So our discussions in the past have centered around informing people who are currently incarcerated of their rights or opportunities to petition for resentencing. We also adopted 3 principles, numbers 4, 7, and 8, that directly reference notice to victims and the prosecutor and the incarcerated individuals. Susan?
Discussion, suggested amendments?
There's no discussion, no amendments. I'll entertain a motion to accept recommendation number 6.
So moved.
I think I heard a second, but it was kind of garbled. So did we have a second?
Yeah, I can second that. I can second that.
Okay.
Been moved. Okay.
All
It's been
right.
moved in second. Kathy, please.
Kelly Cassidy,
Yes.
Robert Peters,
Yes.
Ari Jones,
Yes.
Scott Main,
Yes.
Sharon Mitchell. I don't think he's back yet. Latoya Hughes. Oops, Latoya. All right, we'll come back to Latoya. Lisa Daniels,
Yes.
Joby Cates,
Yes.
Orlando Mayorga,
Yes.
Mitchell Davis,
Yes.
Shobha Mahadev,
Yes.
Marcus Salone,
Yes.
Cheryl Ingram.
Yes.
Okay. Moving on to recommendation number 7, Chairman.
Okay, the recommendation reads as follows. A petitioner who is unable to afford counsel is entitled to have counsel appointed at no cost to the defendant to represent the defendant for the resentencing petition and proceedings. Any comment or additions? Hearing none, is Chair will entertain a motion to
Move to
accept.
pass.
I'm sorry,
So moved.
Seconded.
been moved in second. Ms. Saltmarsh,
Kelly Cassidy,
Yes.
Robert Peters,
Yes.
Ari Jones,
Abstain.
Scott Main,
Yes.
Sharon Mitchell. Not with us yet. Latoya Hughes,
I would like to abstain from this one, and I apologize, I couldn't unmute myself for the last one. I wanted to note an objection to the last one, recommendation number 6.
all right, are you abstaining from?
From
Number-
7,
Okay, you're, for number 6, are you voting no?
I'd like to note an objection, yes, to number 6, yes.
Okay. All right. Then going back to number 7, Lisa Daniels,
Yes.
Joby Cates,
yes,
Orlando Mayorga,
Yes.
Mitchell Davis,
Yes.
Shobha Mahadev,
Yes.
Mark Salone,
yes.
Cheryl Ingram.
Abstain.
All right. On to number 8.
Number 8 reads as follows: a defendant who files a pro se petition and subsequently retains or is appointed counsel shall be entitled to amend such petition with the assistance of counsel. Any discussion or amendment? Hearing none, I'll entertain a motion to adopt.
So moved.
Second,
Seconded.
it's been moved and second. Kathy, please.
All right. Kelly Cassidy,
Yes.
Robert Peters,
Yep.
Ari Jones,
Abstain.
Scott Main,
Yes.
Sharon Mitchell, still gone, Latoya Hughes,
Abstain.
Lisa Daniels,
Yes.
Joby Cates,
yes,
Orlando Mayorga,
Yes.
Mitchell Davis,
Yes.
Shobha Mahadev,
Yes.
Marcus Salone,
Yes.
Cheryl Ingram.
Yes.
All right. 1, 2, 3. We have 10 yeses, 2 abstentions.
So number 8 carries. Number 9 reads as follows: the court shall review petitions for resentencing and determine eligibility based on the factors established by the General Assembly. Comment? Is there any comment?
I'd like to invite some discussion here.
Please.
My question, if, and forgive me if I sound naive here, but what section of the court, what area of the court is going to do this review process? Is it the attorney? Is it the judge? I mean, is it the prosecutor? Is it the judge? Who's doing this?
I take it would be the hearing officer, the person identified to hear the petitions.
Yes, the previous discussion on this was around having the ability for petitions that did not meet the eligibility criteria to be screened out without further consumption, I'll say, of court resources. So the judge that gets the motion would have the review of whether or not on its face the motion met whatever eligibility criteria are established by the General Assembly.
Okay, thank you.
Shobha?
I guess I have one question just related to what Scott had raised earlier. In these recommendations, this set of recommendations like 9 and 10 and 11, we're referring to eligibility. I guess I don't want there to be confusion because we've laid out some stuff about eligibility earlier in the recommendation. So I don't know if we should refer to that in some way, even though we are giving the General Assembly, of course, power to figure out what the specifics of that. I'm just wondering if anyone feels like we need to refer to taking into account, say, the eligibility factors laid out here or something like that.
I don't have a problem with that.
What's the suggestion, Shobha?
I think it would be something like, I'm wordsmithing on the fly again, but when we're referring to eligibility here and determine eligibility, taking into account, I don't know if it's taking into account or something like that, the eligibility factors or eligibility recommendations as outlined in number 2, I think it was, and based on the factors established by the General Assembly. Let me see if I can write that better than I'm saying it. I just don't want there to be a confusion between 2 types of eligibility.
Anyone have suggestions for language here on the eligibility question? Shobha, do you want to run yours past us again?
I'm trying to edit on the fly. The court shall review petitions for resentencing and determine eligibility, comma. And I'm just going to scroll back to number 2 here. Oh, sorry, that's a different document. Hold on. Yeah. Considering the criteria specified in recommendation number 2. And based on. I don't know if that accomplishes it.
But if the General Assembly doesn't go with the criteria established in recommendation number 2.
Right. I mean, I guess it's sort of like we're recommending something, right? So like if we recommended something in number 2, I just didn't want to sound like we were coming off of what we're saying too. So I don't know if that accomplishes that or.
What if we added at the end, established by the General Assembly pursuant to recommendation number 2? Then we're not saying that what we said in recommendation number 2 is going to be the law. We're saying that in best case scenario, the General Assembly will love our recommendation and go with it, but that recommendation doesn't establish anything. It's just a guide for the General Assembly.
Yeah, I'm okay with that. I wonder if anyone else has a thought, but yeah, I think that would also do what I'm worried about or address what I was concerned about.
Other comments?
Would you kindly read the amended recommendation?
The amended recommendation: the court shall review petitions for resentencing and determine eligibility based on the factors established by the General Assembly pursuant to recommendation number 2. And then Latoya has a question. Latoya, why don't you just state your question?
So again, we've kind of talked about the fact, can you guys hear me?
Yes.
Yeah.
Okay, we talked a little bit about the fact that, a lot of the recommendations are fairly general, and I understand from the legislator's perspective as to why that is. However, I'm curious as to, this is the recommendation, but I would imagine that we're going to be providing some meat under the recommendation in the report. And I just want to put out there, you know, are we putting the meat that people have discussed in the report under the recommendation?
Yes.
So that the, you know, the concerns, the are at least out there for consideration. Because what I would hate to happen is that, you know, we provide all of these recommendations, but there are things that just won't work. And we're not providing the legislators with enough information initially as to why certain things won't work or what's needed to make them work in this report so that they get off to an effective start.
To the extent that we have discussed what would work, which I will say we haven't discussed that in very great detail in past meetings. Yes, I mean, the approach to the report is we're going to obviously list the recommendation and then with the rationale for that recommendation. And I'm going back and listening to meetings and picking out the most salient points made from every viewpoint, as well as incorporating the information, the factual basis, I'll call it, from the materials that were provided pursuant to each meeting. I will say this recommendation in its original form from the American Law Institute was framed in terms of the court being able to dismiss petitions at the initial stage if the eligibility criteria were not met. So this is the way this is written is a little bit different. And I invite further comment to flesh out the concerns that members have about either implementation or what the process might look like.
Scott?
Yeah, I sort of jumping off of what Kathy was just sharing. I mean, I think that we're really, it's hard to be looking at number 9 in isolation because 9, 10, and 11 really work in harmony together. And I think we are, through these three, we're sort of identifying kind of the entry point into an actual, how do we get the gears moving? And so we're here in 9, I think we're talking about that sort of plenary or sort of initial review by a court. 10 very much is like as a partner to 9 to allow for dismissal of petitions. And then 11 is like, the 9 gives us a point, and then we have our 2 diverting paths. Like if not eligible, you get a summary dismissal, and if eligible, then we move forward down the path. And so I think I don't know that anything more is needed in 9 because we're going to get to some of those other points when we get to number 10 and get to number 11.
Do we need 9? I mean, we're studying a process that is motions for resentencing. It kind of goes without saying that a motion is going to be filed and reviewed by the court. Don't courts do that anyway?
If 9 is not included, then 10 will be.
Ari, I see your hand.
There's a difference between courts reviewing things generally and then reviewing this based to determine eligibility as is suggested here. One of the whole reasons for discarding any cohesive and concrete factors in some of our other more general recommendations has been that the court would have the power to determine eligibility moving forward to determine whether someone even gets fully into court to have their petition reviewed. So if this becomes unnecessary, or if this is deemed unnecessary, won't this just lead to an opening of the floodgates? I guess I'm confused as to what everyone is saying here.
Kathy,
you
could you
think-
say a sentence or two more about why you think it might be unnecessary to have number 9?
I'm gonna actually now, if we have a recommendation, rather than 3 recommendations, and Ari, if I'm understanding you correctly, the step of making it clear that the court is allowed to review and take action based on an eligibility determination is a critical step. Is that right?
It's a preliminary, yes, and it's a preliminary step before determining whether or not the petition even gets to go forward to a hearing.
Right. So, okay. In that case, I'm going to withdraw my point that maybe we don't need 9 and go in favor of more granular detail. And again, going back to what we've talked about in the past, we had 2 different frames really. One was we don't want to glut the court with frivolous petitions. So there needs to be a mechanism whereby eligibility is clearly stated and the court can dismiss a petition. Number 2 is we need to have, for people who are pro se, they need to understand what they need to say in their motions to, open that courtroom door. And it all has to be part of the fair mechanism to review the resentencing decision. So.
Any comment, discussion?
Yeah.
Is there, excuse me, is there a motion regarding the amended recommendation number 9, which reads as follows? The court shall review petitions for resentencing and determine eligibility based on the factors established by the General Assembly pursuant to recommendation number 2. Their motion? It will,
Well, do we need more discussion? Do we have other questions?
I'm wondering, sorry.
Scott, go ahead.
I forgot the arm raise. If sort of again, what if we went back to the original language, just the unamended language? And I guess one of the reason I say that is to the extent that we had any sort of a because of our discussion on number 5, I think that we've adequately sort of set forth who it is that we're talking about, and here I think we're trying to clarify the ability to do a summary dismissal, which we're going to get to in number 10. So I think 9 cleanly states, this entry point, this, who gets to go through the door, as set forth by however the General Assembly sets this up. So I would move number 9 as originally drafted.
Shoba?
I'm okay with that. What like I said, I would vote for the original too. I was just raising the concern, and I'm curious to see if Scott thinks it is a concern now that I hear you when you say we did lay out eligibility. I agree with that. And that's why I'm comfortable with the following recommendations. I was just worried that the fact that we're saying that we're saying the General Assembly will establish these factors, if that feels like a contradiction to our recommendation number 2. But if people don't feel like that's the case, I think the original would be fine.
So you're withdrawing your proposed
Yeah.
amendment?
I guess I just wanted to hear if Scott would offer a response to that point, and then based on that, I'll probably withdraw it.
If I could say, there's a motion on the floor without a second.
Oh, which one is it now? The recommendation.
The original
motion.
was moved by Scott. Is there a second?
I feel like
Second.
that Shobha just was asking for clarity before on that. I think that if Shobha got that answer, maybe that would be, allow us to move forward.
That's correct. Could we do it that way? Is that allowed?
Is there a second?
I'll withdraw my motion to address the question. I mean, I think that I feel like we have set forth, you know, that all of these are going to be read together, and we have established who is eligible. We've established the General Assembly should then set forth a process based on who is eligible, and it's sort of, now that we're down in hearing, we're already talking about this one subset already identified within the body of this one thing, that these are not these recommendations do not exist in isolation. They exist as a unified whole. So as you progress, we're not creating a new eligibility pool, and there's certainly no eligibility pool that, like, you know, the tension that I saw when first reading this was the court doesn't get to be making an eligibility determination, but then it's tied to the factors set forth by the General Assembly, and the General Assembly has already received the recommendation of who should be eligible. So I think that this is just a natural corollary to what we have already identified as the population for whom has this possible pathway forward.
Here's an observation. It does seem that the issue here is the language of determine eligibility. So maybe it's something like considering the factors established by the General Assembly, that revisiting eligibility in this recommendation, as well as the one that follows, is not what's intended. Is that correct?
I believe that is correct. Yes, that the tension is sort of this adding this, the language of determine eligibility, I think, is what's making some of us uncomfortable.
Right.
So what the court will be looking at is whether the petition meets the eligibility criteria sufficiently to move into the next phase of a hearing.
I think the
So-
language of determine is what's at heart here. So maybe it's considering.
That's what I'm saying. The court reviews for compliance essentially with the eligibility criteria, or reviews to determine if the motion meets the eligibility criteria established by the General Assembly. Does that address the concern?
Cheryl?
Are you asking the court to make a determination without an objection from the state, to just look at the petition and make a determination without an objection? Is that what you're asking?
The original, well, yeah.
Really? Is that what we're talking about? That the defendant files the petition and then the court goes through the petitions and determine if they meet eligibility without an actual objection and allowing both sides to argue? Is that what we're talking about?
Originally, that is what was contemplated.
Okay.
There's, but originally, and it was we talked about the in frivolous petitions in the post-conviction sense. And basically, if we're going to create this new process, there needs to be a way for a petition that is facially not eligible. Let's say, for an example, let's say that the law provides that everybody can file these except people convicted of murder. The court gets a petition from somebody convicted of murder. Do we need further process to determine that petition should not go forward? And I think the nature of the recommendation originally, and in terms of what the ALI principles were, was there should be no further consumption of resources on that petition. It facially does not meet the eligibility criteria. So therefore, the court can dismiss it. But I hear what you're saying. That's not how we usually do things.
Not really. I mean, basically you're saying every petition that's filed goes to the judge goes through them and then makes a determination. I mean, and I know that ultimately it's going to be set up so that the petitions or the petitioner is going to have to give notice at least to the state, who is the person who should object in court.
Scott?
I mean, they don't really go to the judge until
Right, until there's
something here to me.
I'm sorry, Cheryl, I didn't mean to interrupt.
No. I'm finished.
I think that where we are, like, because I believe my understanding of number 9, and again, sort of 9 and 10 read in union, is that this is a screening process. And this is a process that would be not dissimilar to first stage post-conviction petitions. And that by operation of law, there can be no input from the state at that initial review stage. The contemplation is that this is a pure question as to whether or not one is eligible. It's not something that needs objection or not. It's, do you fit within one of these boxes? There is room, obviously. I think no one is denying that there won't be room and space for a fully litigated process. But here, in terms of eligibility, I don't think it's that uncommon for it just being a question to the judge without input from the state as to the eligibility question. Again, my understanding here is like it's who gets to open the door, not ultimately entitled to whatever the ultimate recommend or the
Kelly?
I guess the ultimate aim is a reduction in sentence.
Kelly?
Yeah, just to piggyback on that a little bit, is the issue here the perception that saying eligibility means somebody's eligible to be resentenced versus eligibility for a resentencing hearing? Is that perhaps the distinction we're looking for? For basic eligibility or something to that effect?
Well, that addition might better clarify the purpose of number 9, and
I'm not making this out.
Cheryl kind of addressed your concern.
Mark, you're breaking up. Can you repeat what you just said?
I was just adopting Kelly's observation and suggesting that maybe by adding the simple wording,
I think we've lost Mark.
Yeah, so I think what he was saying is that might help. I think he's asking about the wording. So I would say, she'll review petitions for resentencing and determine if petitioner meets basic eligibility criteria for a resentencing hearing
Okay.
based on the factors established by the General Assembly.
Okay, Abby. Yeah.
Cheryl, is that better?
I'm unclear.
Does that,
I'm unclear what process you're really contemplating with this recommendation. Based on how court operates, when the defendant files his petition, and you're saying the court's going to review the petition to determine if he meets the criteria, then you're saying that means the court's going to get the petition and make that initial determination by themselves without any other party. I mean, what are you saying? I mean, when does the court actually get a petition and determine it without it being in an open forum whether or not the person is eligible?
see,
I'm not sure what this means.
when we rule on PCs, there's an initial finding. There's no adversarial process at that point. As an example, just a determination of whether it's going to go forward or not.
Okay. But you know how much has to be read to determine that, right? In a PC. Because here, I mean, simple eligibility, if you're saying, it seems like everybody's saying we shouldn't knock anybody out. Anybody should be able to file except I think I heard earlier, I thought I heard earlier, except someone's charged with murder, but we started out saying that they should also be, so I'm not even sure.
That was just an example.
That was an example.
That was not a suggestion.
Okay.
That was
I
just
thought that
an
was an
example.
From the last discussion, it seemed like people didn't want to exclude anyone. And if that's still your position, then I don't know why we need this. So I'm not
Well,
sure.
I think we're also contemplating that the General Assembly might exclude people.
I'm sorry?
Like it also contemplates that the General Assembly might exclude people. The ultimate law might, the final product may actually have some exclusions, but also, even absent anybody being excluded, there are going to be people who fail to complete the petition correctly. There are going to be people who do frivolous petitions. I think it was based on that desire to have an opportunity to weed out and avoid undue burden. And we're trying to land on the language that provides that checkpoint.
Cheryl, what is your concern? Is it due process?
Yes.
I think my concern is, I don't know what you're trying to do. At one point, you're saying everybody gets to file, period. And if that's the case, then you don't need this. If you're saying there are certain criteria, then that's going to come up once the criteria is there. Clearly, if the person doesn't qualify, the petition will be stricken. But when you put something like this in and says the court shall review it for that, it's automatic. If you look at it and it doesn't fit in the criteria, you dismiss it. So I don't know why we're telling the court to do what they do. I'm missing the point. I'm sorry, but I'm done.
Scott?
From my understanding, that's all we're asking right now. And it's creating a clear, we're just trying to go step by step and making it so that, the General Assembly will decide who is eligible, what the criteria is. And then this is the screening mechanism where the judge decides, do you fit within one of those boxes? If not, your petition is stricken.
So now I feel like we've gone a little bit full circle because the question becomes, do we need this recommendation? What is accomplished by having this recommendation?
What isn't stated in number 10, which is stated in number 9, is that we want a judge to be making this decision.
Oops.
Well, I guess it is sorted in number 10 anyway, since we're asking for the orders set forth.
Cheryl?
I guess my position is I don't know why we need it. I think I don't know why we need it.
Well,
Is there anyone who can speak to why we need this?
the only difference that I see between 9 and 10 is that 9 clearly states that the criteria is established by the General Assembly.
Kelly, can you elaborate on your comment in the chat?
Yeah, sure. So I said in the chat, if the General Assembly, to Cheryl's point, as we are recommending it, maybe we don't need this based on our other recommendations. But if the General Assembly, in their infinite wisdom and deep intellectual capacity, wants to create a list that has, including factors and excluding factors, well, then they also have the capacity to create a process by which there's a screen to screen them out.
So can
we can be silent on it.
Can you propose some language?
I would say it's just delete this recommendation. And if we're silent on it, because we are not making recommendations that contemplate excluding factors, then we don't need to speak to it. I mean, at the end of the day, I guess what I'm saying is this is not a hill worth dying on for anybody.
Is there any objection to the language as originally proposed at this juncture?
I think the objection is to including this recommendation at this point.
Okay, does anybody feel strongly that this should be included? So do we want to move on to 10?
I think we need a motion to and vote on whether we're going to exclude number 9.
Move to exclude number 9.
Second? Any second?
A second.
Moved and second, that number 9 be stricken. Recommendation number 9 be.
So with that motion, Kelly Cassidy?
Yes.
Robert Peters?
Yes.
Ari Jones?
No.
Scott Main?
Yes.
Sharon Mitchell? Not back yet. Latoya Hughes,
No.
Lisa Daniels,
No.
Joby Cates,
Yes.
Orlando Mayorga,
I abstain.
Mitchell Davis,
Abstain.
Shobha Mahadev,
Yes.
Mark Salone, Mark, are you still
Yes.
with us?
Yeah,
Okay.
I am.
Carol
Yes.
Ingram.
Yes.
All right, we have 1, 2, 3, 7 yeses, 3 nos, and 2 abstentions. So the motion to exclude carries.
Carries. All right. That brings us to number 10, which reads as follows. Resentencing petitions shall be dismissed if they do not meet the eligibility criteria. Such dismissal shall be a final order. The court shall set forth either in open court or in writing the reasons for granting or denying a petition. Comment?
I mean, isn't this sort of a restatement of the one we just deleted?
It is. Yeah.
Chief Davis?
Yes, I guess, I don't know if it's a comment or a question or what, but we talked earlier, but I guess it passed earlier when we were talking about not just people whose sentencing criteria or the type of offense sentencing for the offense changed, but those who had lengthy sentences. And I abstained from that earlier because I really had some unreadiness on that whole process. In that if we're talking about people with extended sentences, being a violent offender or something to that effect, I think needs to be taken into consideration. But specifically to this, circumstances that may deny a person right now may change. For example, you got somebody who's serving an extremely lengthy sentence, and right now they don't fit the criteria, but 10 years from now, they got terminal cancer, and they're only going to, they're living another few months or something like that. I think that there might be some exceptions that we might need to take into consideration. I guess that's my comment.
Thank you. Other comments? Cheryl?
I think I want to respond to the chief's concerns, and I think I don't have all of the recommendations in front of me for some reason. Maybe I deleted it, but I think we're talking about two different things, and I think that's kind of where we're mixed up. Whether we're talking about when a petitioner files a petition and his petition is denied for whatever reason, once there's a hearing on it, we talked at one time about saying that that would be a final order, but you could refile within X amount of time so that once it's denied, people don't go back the next day and refile. We talked at one point about a time limit, which would, I think, encompass what the chief is talking about. Because this is the final order, doesn't mean it's final forever. It means it's final and it's not appealable at this time. But we talked about setting out a criteria where they could refile later, which is different from, I think, what we keep saying, whether or not they meet the eligibility criteria. And I think each time you include that language without us understanding what you're saying, it sounds like it's a two-step process. And I don't know if we've really had that discussion fully.
Shoba?
I don't know if I'm going to answer Judge Ingram's question, but I was going to answer hopefully the Chief's a little bit, which is I think that I completely appreciate what he's saying about changed circumstances. I do think our purpose in approving number 2, which was where we kind of laid out these criteria. And one of those criteria, just remind folks, is that the showing no longer advances the interests of justice or the promotion of public safety. I guess my interpretation is that might cover some of the things the chief is concerned about, which I completely agree with. So hopefully, my hope is that we've drafted this broadly enough with those concerns in mind.
Comment?
Are we ready to vote?
No, Cheryl's gonna come.
I'm sorry, Cheryl?
You know what? Do we have maybe it's just me. I don't have a list of all of them so that I can refer back. Is there a list?
They're in the
There
agenda.
was. I'm
They're
sorry.
attached to the agenda pages 3 and 4.
Okay, thanks. Email from Mark.
But the ones previously voted on were in a separate document sent to you before the meeting with all the other meeting materials.
It was a Tuesday email sent by Michael Elliott.
Mike, can you go ahead and send those to Cheryl again? So she has them at her fingertips.
September 6th.
In my mind.
Can you send them, just send them to everybody?
We will send them to everyone.
And I guess for completeness sake, I think it's also, I think some of the confusion is that, you know, we're in recommendation town. We also have gone through the process of agreeing upon principles. And so some of what Judge Ingram is referring to, I think is captured in the principles that we've agreed upon. So it might, again, if one wanted to have everything out in front of them to make sure that we're telling one cohesive story, it might be helpful to have those up as well.
Abigail, can you forward to Mike the list you gave me yesterday of the principles, and then he can include that in his email? And then we will have our full story.
Can we go back and have another reading, Kathy, of this recommendation?
Sure. Resentencing petitions shall be dismissed if they do not meet the eligibility criteria. Such dismissal shall be a final order. The court shall set forth either in open court or in writing the reasons for granting or denying a petition.
Discussion.
Can I get some clarity around the final order? Such dismissal shall be a final order. That sounds to me as though the person who is not deemed eligible or is deemed not to meet the eligibility criteria does not have an opportunity to resubmit a petition. Should there be a time frame in there, or is that what that actually says?
Lisa, is there language that you would add?
Hang on, Susan.
I probably
Why
should
don't
get,
you, let's have
yeah, I want to
Scott
get some
respond.
clarity first. I'd like to get some clarity before I could add some language.
Okay, Scott?
I would suggest, filling in a blank with the curse word of your choice, and then add the word lawyers after it. What the language of a final order is magic words that are necessary to preserve the right to an appeal. So it is not it's not nearly so scary as it sounds, and it is just to make it clear that this decision, that if if a judge strikes something for not meeting eligibility, that is something that could be reviewed. And again, we're jumping ahead in part in the story to, looking to an appellate right, but this is language there to make sure that there would be an opportunity to review. But to your point, and to the point of sort of once we have all of this put together, I think we'll make it abundantly clear, as we've already agreed upon, that we imagine that this is something that someone would, if denied today, 5 years from now, 10 years from now, whatever it is, they can and should have another opportunity, that this wouldn't be the one and done.
So a final order on that petition?
That's what I just heard. And so with that, thank you so much for that clarity. Scott, I do not have a recommendation for any other language, Susan. Thank you.
So the initial review is the checkbox. Do you meet the checks that the General Assembly has established? That's a final order that the person can take to the appellate court and argue that in fact they did meet the eligibility criteria and should be allowed to move on to the hearing phase. And as to Susan, your suggestion, shall be a final order on that petition. Honestly, as Scott said, this is legal technical language and it doesn't need to have anything else with it. For clarification for lay people, we could add that. Do we want the eligibility determination to be appealable? I think that's the seminal question.
Well,
Is there a recommendation that speaks to that, or are we addressing that in this recommendation?
there is number 16, I think.
Well, this recommendation addresses the eligibility determination alone. Number 16 addresses the appealability of the final resentencing motion disposition.
Well, that one needs some clarity.
Shoba?
Maybe again, it's a curse the lawyers moment, as Scott flagged, but I did feel like this was clear, this recommendation based on final appealable order. I do wonder, I think this was raised earlier, if in the sort of comments that go along with these recommendations, if this part of that discussion would be, captured perhaps as to why this phrasing exists. And then in terms of appealability, I do feel like noting that I think this tracks somewhat what happens with post-conviction, where there is sort of this initial kind of screening and that is appealable as well. And so I think this is somewhat a reflection of that, although obviously not identical to that act. So that's what it reminded me of, at least. So I felt like this was clear and helpful to have that final order language.
So maybe we should insert final appealable between final and order. So it's for people who aren't legal technicians, they get that that's what that means.
I'd be okay with that.
Okay.
Not sure if any of the other lawyers are going to be irritated that I said that, though. So.
Well, our audience is not lawyers. It's, well, so there will be some lawyers in it, but I think hopefully members of the public will be able to read these recommendations and understand what they mean. So do we have, I guess, any further discussion or questions or concerns?
is there additional language being?
We
Yeah.
added one word. We added one word, Mark. So this is, it now reads, resentencing petitions shall be dismissed if they do not meet the eligibility criteria. Such dismissal shall be a final appealable order. The court shall set forth either in open court or in writing the reasons for granting or denying a petition. I think maybe the granting or denying a petition is not the right language here. The reasons, what we want in that final order is the reasons underlying the eligibility determination. We're asking in number 16, the granting or denying of the petition as a whole will be appealable. And we would love to have some reasoning from the judges in those orders. So maybe we can just say the reasons for its decision, because it's an eligibility decision. It's not a decision on the merits. We need 4 before it's, Abigail. And then period after decision. So with that edit, the recommendation reads, resentencing petitions shall be dismissed if they do not meet the eligibility criteria. We're talking about the eligibility criteria established by the General Assembly, but I don't think we need to say that. Such dismissal shall be a final appealable order. The court shall set forth in either an open court or in writing the reasons for its decision. Ari?
If you don't meet the eligibility criteria, then you don't meet the criteria. If it were just checking off boxes based on what the General Assembly or whoever is supposed to be coming up with this criteria is establishing. So why does it need to be appealable? I guess, you know, if you're saying that you have to have been in prison for 10 years, you have to be over, 35, and, you have to be 6'2" or taller or something, whatever the criteria are going to be, if you don't meet those 3 prongs, then you just don't meet them. So what is there to appeal?
Comment? Scott?
I think the devil will be in the details. I mean, it really will depend upon what the eligibility criteria are as set forth by the General Assembly. I think that if what the ultimate recommendation is whether or not one is serving a X number of sentence and you've served 10 years of said sentence, I'm talking myself into,
I'm sorry.
I mean, I think that the chances are there is going to be something that is not so cut and dry, that is a determinative eligibility criteria. And so it's to ensure that we're keeping fairness in this process. And that's the purpose behind ensuring that the process is due to the petitioner. And so I think that that's what the aim is. But if the ultimate recommendation is something very different, then I guess I would have to agree. But I don't believe that that's, if you look at eligibility criteria number 2, there is a lot of room for what the General Assembly might come up with in terms of what would make someone eligible. And that is the review that we're hoping to enshrine, from my perspective, the we being my perspective of what is being put forth.
I think, okay, I apologize.
No, go ahead. Ari, were you finished? Go ahead.
Thank you. I think the opacity behind having deferred, not having context around what the eligibility criteria will be is making it very difficult to support something like this. So one of the issues with essentially saying, oh, we'll deal with this later or when it comes up is that when you try to enshrine niche things like this is going to now be a final appealable order based on eligibility criteria that we don't have to compare and that we don't have to critique at this time, it's really difficult to support something like this that will inevitably open the floodgates to all sorts of unique and creative potential litigation down the road, especially if the hope is that this won't just become the kind of muddled pool that is now PCs.
Discussion?
Latoya, your hand's up.
Yes, I was just going to say what Ari said. I think my biggest concern is that we're not providing enough context, and we're leaving too much open, at least in our recommendations, right? I mean, the legislatures have the ability to agree, disagree, go in a different direction, absolutely. But, you definitely have people on the call who have experience in all of these places. And I really think that we need to provide some more context as it relates to all of the recommendations in order to get to the heart of what we want to accomplish, which is a process that works, right? Works effectively and efficiently at all levels. And I just have concerns that we're not getting there by such open-ended recommendations.
Other comment?
Shall we take a vote? I'm certainly not trying to cut off the conversation. But if there is none, let's take a vote.
We need to call for a motion.
Okay, Kathy, can you read?
Sure.
Great.
The edited recommendation: resentencing petitions shall be dismissed if they do not meet the eligibility criteria. Such dismissal shall be a final appealable order. The court shall set forth either in open court or in writing the reasons for its decision.
Okay, that is the proposed recommendation. Their motion to adopt.
So moved.
There a second?
Second.
Been moved in second. Kathy, please.
Kelly Cassidy,
Yes.
Robert Peters,
Yes.
Ari Jones,
No.
Scott Main,
Yes.
Sharon Mitchell. I don't think we have Sharon back yet. Latoya Hughes,
Abstain.
Lisa Daniels,
Abstain.
Joby Cates,
Yes.
Orlando Mayorga,
Yes.
Mitchell Davis,
Yes.
Shobha Mahadev,
Yes.
Marcus Salone,
I abstain.
Cheryl Ingram.
Abstain.
We have 7 yeses, 4 abstentions, 1 no.
The motion carries. Is this a good time for a break?
I think it is. We had a break in our agenda. and
We do, but let's take it now. Kathy, will you speak to the exit of a lot of people at noon?
Yes, we are going to be losing 4 of our members for sure at noon. So one question is, should we go ahead and adjourn the meeting at that time? And because we have public comment on our agenda later than that, obviously we would have public comment before we adjourn, and I would just then keep the meeting open in the event other members of the public joined us later on with the intention of offering comment. And then I would report those comments back to the members before our next meeting. That is my proposal. I'd be interested if anybody is a better Open Meetings Act expert than I am, and thinks that would not comply with the requirements of that act, please speak up.
Sounds good to me.
All right. I guess I would ask, does anybody object to that approach? Okay.
Abigail, can you put recommendation 11 on the screen? Thank you. Chairman Sloan?
Okay. Number 11 reads follows. Upon a determination of eligibility, the court shall conduct a resentencing hearing. Comment? Addition? No comment, no amendment? I'll entertain a motion regarding.
So moved.
Okay, second? Second, please.
I'll second that.
Been moved in second. Kathy, please.
Kelly Cassidy. Kelly.
Sorry, I was having trouble with my unmute. Aye.
Robert Peters.
Aye.
Ari Jones.
Dang.
Scott Main.
Aye.
Sharon Mitchell. Sharon is not back yet. Latoya Hughes.
Sustain.
Lisa Daniels.
Yes.
Joby Cates.
Yes.
Orlando Mayorga.
Yes.
Mitchell Davis.
Yes.
Shobha Mahadev.
Yes.
Marcus Salone.
Yes.
Cheryl Ingram.
Yes.
Okay. On to number 12.
Okay.
Can you
Number
give
12.
us the vote, please, Kathy? The
Pardon me?
totals.
Oh, I'm
Can you-
sorry. Yes,
the-
yes. 10 ayes, 2 abstentions.
So it carries. Okay, number 12 reads as follows. The sentencing court shall consider, but not be limited to, the following factors. 1, the age of the petitioner at the time of the offense, and the age of the petitioner at the time of the sentence modification petition. 2, the nature and circumstances of the offense. 3, the history and characteristics of the petitioner at the time of the petition for reduction in sentence, including rehabilitation and maturity demonstrated by petitioner. 4, the petitioner's family and community circumstances. including any history of physical, emotional, or sexual abuse, substance abuse, trauma, or involvement in the child welfare system. 5, any report from a physical, mental, or psychiatric examination of the defendant conducted by a licensed healthcare professional, validated risk assessment if available. And 6, any changes to the law governing criminal convictions, dispositions, or length of stay since the time of sentencing. 7, any other information the court determined is relevant to the decision of the court, including any statement by a victim of any offense or family member of the victim, or the recommendation received from the state's attorney. Okay. Comment?
Chief Davis?
Yes, I would ask that we look at number 5 and consider removing if available. I mean, we're asking for all these other things, but then one of the most important things being a risk assessment, we're making that optional.
Other thoughts?
Let's see.
Latoya, I might ask you, is risk assessment up and running completely in DOC?
We are doing risk assessments, yes.
So that would not be a problem to get one done for a motion for resentencing.
Right, I don't foresee that as being a problem if that is indeed one of the requirements of it in the future.
Okay. So Chief, is your suggestion that we delete if available?
Yes, ma'am.
Okay.
Okay. Any objection? Okay, so the amended recommendation would delete the 2 words if available. Is that correct, Chief?
Yes, that's
Yes,
been
sir.
done.
Yes, sir.
Okay, are we ready for the vote? Is there a motion?
So moved.
Second?
Seconded.
It's moved and second. Kathy?
All right, Kelly Cassidy,
Yes.
Robert Peters,
Yep.
Ari Jones,
Yes.
Scott Main,
Yes.
Sharon Mitchell, Latoya Hughes,
Yes.
6 miles.
Lisa Daniels,
Yes.
Joby Cates,
Yes.
Orlando Mayorga,
Yes.
Mitchell Davis,
Yes.
Shobha Mahadev,
Yes.
Marcus Salone,
Yes.
Cheryl Ingram.
Yes.
Okay, on to number 13.
The breakdown on a vote.
Oh, I'm sorry. We have unanimous support.
Okay, great. And it carries. Number 13 reads as follows. Calculating the new term to be served by the petitioner, the court shall credit the petitioner for any jail time served toward the subject conviction, as well as any period of incarceration credited toward the sentence originally imposed. Comment? Amendment? Come on.
Discussion? Kelly, are you saying something?
I was just getting ready to move that we adopt this recommendation.
Thank you.
The second?
I'll second that.
It's been moved in second. Kathy, please.
Kelly Cassidy,
Yes.
Robert Peters,
Yes.
Ari Jones,
Yes.
Scott Main,
Yes.
Sharon Mitchell, Latoya Hughes,
Yes.
Lisa Daniels,
Yes.
Jody Cates,
Yes.
Orlando Mayorga,
Yes.
Mitchell Davis,
Yes.
Shobha Mahadev,
Yes.
Marcus Salone,
Yes.
Cheryl Ingram.
Yes.
All right, it is unanimous.
Okay,
Mr. Chairman.
13 carries. Number 14, the court shall be authorized to depart downward from any mandatory minimum or mandatory sentence enhancement. The new modified sentence term shall fall within the authorized range for the class of the offense of conviction. Any comment, addition?
I would like to give some context because we did have some legal analysis presented. I asked for it and was provided it. And, basically the question is, a mandatory minimum is a sentence that is established by the General Assembly. A court cannot impose a sentence that is not authorized by law. So the question is, can a court, if given the authority to depart downward, actually do that in this context of a resentencing motion? And obviously, this is new, so we don't have anything that is tried and tested. And, we don't have agreement from the legal eagles on this task force about whether a court could do that. So the question would be establishing that authority through the resentencing motion process. And I would note that we do have examples of that. The Safe Neighborhood Reform Act that I think was passed in, I'm going to say 2019, maybe 2018, created a new mandatory minimum for repeat offenders with gun crimes, and allowed generally they're referred to as safety valves, but allowed a downward departure if the judge found certain specific factors. We've seen that in the federal, the reforms on the federal level. And I think it was also, we had, I think, a provision in the juvenile parole bill that also allowed for that. So we don't have consensus amongst our legal members on that issue, but we do have examples in other cases where a downward departure has been allowed and authorized specifically by legislation. Ari, I see your hand up.
Yes, I just want to go on the record as reiterating all the points that I made in our last meeting regarding mandatory minimums and how one cannot downwardly depart below a mandatory minimum through this process. Ultimately, this is a jurisdictional issue. It's giving petitioners the right to come into court and ask a court to review their sentence. So it's giving someone an avenue to get back into court. Seeking to change sentencing laws through this process, I do not think is an appropriate use for whatever is attempting to be done here. And also in allowing a new modified sentence to fall within a range of years, that's signifying a return to indeterminate sentencing. So to the pre-1978 scheme of sentencing that existed here in this state. And if that is what is attempting to be done here, so be it, but that is a separate issue than whether someone should be able to have a judge reconsider their sentence. I do not think that can be done here, and I just wanted to go on record as saying that.
It's noted. Any additional comments?
We have two hands raised, Scott and Shoba.
I will just speak real quickly, and I think I agreed with the first part of what Ari was saying, in that judges aren't, judges don't have the ability to depart from the ranges set forth by the General Assembly. But the General Assembly gets to set the ranges. And so I think that there are, I think that if the General Assembly wanted to create the opportunity at a resentencing hearing for a judge to have a broader range of penalties for the offense, the General Assembly could do that. It would just require the original, there would just have to be a lot of language like, penalties for class X are 6 to 30 subject to this other provision. And then that other provision would set forth that within this context, there could be a departure from the authorized range. I do think that this language is a little bit confusing as it's currently set forth. The first sentence makes a lot of sense to me. And I think we would have to be clear that the new modified sentence term shall fall within the authorized range of offenses based upon such I guess to the second part of what Ari was saying, I don't think that we should be advocating for a return to indeterminate sentencing. I don't think the resentencing task force should be, advocating for a return of the wild ranges of 10 to 240 years for certain classes of offenses. I think that we're still thinking of class ones would have a range of 3 to 15, or 4 to 50, whatever it is. And then, in the instance of this, they could downward depart. That's, I think, the intention, and I think we could be more clear if that is the direction the task force wants to go in.
Shoba?
I was gonna sort of keep my lawyer hat on a little bit, but not in a technical way. I just wanted to speak in favor of this concept. I mean, we might have to wordsmith that second sentence. I agree with Scott that I think the legislature can authorize this in some way, and we'd have to, I think the detail might be important there. But I did want to just say, this is a huge problem. I mean, our mandatory minimums are exceedingly high. I've been in conversations with state's attorneys, prosecutors, all sorts of folks about clients in a situation where they feel their hands are tied. There's nothing to do because the mandatory minimum was too high. I do think that if we aim to do anything about this issue, we should at least provide a mechanism where this is possible. Not that we move to indeterminate sentencing, but then and you could view it as an exception, but as in a particular case that a judge could do this with the authorization of the General Assembly. I'm concerned about leaving this out entirely. And so I guess I just wanted to put that on record.
Ari?
I think the concern about mandatory minimums being too high is completely fair. And I think that is certainly an issue that needs to be addressed. I think that trying to do that through this process is honestly just circumventing a greater issue, which is that sentencing laws in this state need to be revisited. So this is really just putting a Band-Aid on like very deep wound instead of actually addressing the deeper of the issues, which is why do we have such high mandatory minimums, along with truth in sentencing laws that do not allow for any credit to be applied for any incarcerated person to be able to earn for themselves any type of early relief and release. So I agree that there is certainly an issue with mandatory minimums. I just disagree that the way to address that is through this process instead of actually looking at and addressing the sentencing laws, which the General Assembly also has the power to do.
Discussion.
In the context of presenting evidence of a person's rehabilitative journey or interests of justice, I think one of the functions of mandatory minimums and sentence enhancements is that they preclude consideration of what, in the old days was called mitigation evidence about the characteristics of the person. So if we are going to say that mandatory minimums and sentence enhancements will continue to apply to the same extent and no downward departure, that precludes a person essentially from making the case that their sentence should be modified, particularly if they got towards the lower end. So I think restoring the judicial discretion and, thinking about the equity lens here, I think that disappears if there's not a mechanism or at least some discussion of allowing a downward departure if the circumstances, and obviously it's an argument that would be made in the context of a hearing that the mandatory minimum should continue to apply. But I also agree with you, Ari, that, this is a nibble because we've gone to the extreme with our sentence lengths and the mandatory enhancements. So I see,
Latoya? Oh, sorry, Kathy.
no, I was just going to say, I see Latoya's hand is up.
I just wonder if, there's the
Hello?
opportunity. Can you hear me?
Yes.
Okay. I just wonder if there's the opportunity, right, for the recommendation to be that, in order for this process to work effectively, based on all of the research that has been compiled as it relates to resentencing and providing a second look, that the legislature review or needs to address the mandatory minimums. Again, I don't know that this is the mechanism for that to happen, but can a recommendation be that is, in order for this to effectively work to its full potential, that is something that needs to be done. I don't know that we have to make the recommendation that the court is authorized to do that in this task force.
Scott? Scott?
Yes.
Okay.
So I guess I am speaking through the chat. I put a suggestion in the chat in terms of that I think this language could be, or a suggestion for the language could be to resolve the issue that I'm seeing with that second sentence, and I think that it's worth just for our conversation to be aware of that to the points that have been made so far, I think are absolutely legitimate. I think that there are open wounds right now, and we have what we're discussing is a band-aid, but I think that we should put that band-aid on and then prep the patient for surgery. I don't know, like I think that we should be doing both, but here for the resentencing task force to make it meaningful in a state in which someone that was found guilty of killing someone with a gun is facing a mandatory minimum of 45 years of which they serve every day. If we're not creating, if the General Assembly is not sort of concomitantly creating an ability to depart from that mandatory 25 years to life enhancement on the offense, I think that it's we are in the position to be able to make the recommendation that the General Assembly should create this additional discretion. So I speak in support of authorizing the task force to be making that recommendation.
And the points Latoya made so cogently would be included in the rationale for that recommendation. And obviously, any sentence that's imposed has to be authorized under the law at the time. So deleting the second sentence, I don't think harms the process.
Scott, you have language in the chat that might be useful to read to everyone.
We just made that change on the screen, Susan.
Okay, thank you.
So the new recommendation says the court should be authorized by the General Assembly to depart downward from any mandatory minimum or mandatory sentence enhancement.
Discussion.
Move to adopt.
Second.
Kathy?
Okay, here we go. Kelly Cassidy,
Yes.
Robert Peters,
Yep.
Ari Jones,
No.
Sharon, I'm sorry, Scott Main,
Yes.
Sharon Mitchell, Latoya Hughes,
No, and I just want to be clear that my no is just that I don't believe this is the mechanism in which to make this recommendation.
thank you for that. Lisa Daniels,
Abstain.
Joby Cates,
I'm gonna vote yes with a caveat that a very wise woman told me once that the world is held together with Band-Aids sometimes, and so to stay in support. And that was the year was 1993, and the woman was Michelle Obama. So in her honor, I'm gonna go ahead and in honor of that comment and that advice, I'm gonna go ahead and vote yes.
Orlando Mayorga,
And how can I go against Michelle Obama? Yes.
Mitchell Davis,
I'm going to vote yes. I'm voting yes conceptually. I'm not a lawyer and I don't know if this is the proper form, but from a conceptual standpoint, yes.
right. Shoba,
Yes.
Marcus, Salone. Ooh, did we lose you, Mark?
Chairman Salone, I muted him a little bit earlier. He would have to unmute.
Oh, Mark, you're muted. Okay, I'm going to come back to you, Mark. So Mark Powers, can you unmute him?
I cannot. He would have to do it himself.
Okay. Cheryl Ingram.
While I don't think this is the proper forum, I'm still going to vote yes, because if I don't vote yes, it's going to knock out the people who have the longest sentences that we're trying to reach. So yes.
All right. A thoughtful group. Mark Salone, can you unmute yourself?
I think I just managed to do that. I vote yes.
Okay, you did indeed. All right, so we have 9 yeses, 2 nays, 1 abstention. So the motion carries.
Okay, and at this point, ladies and gentlemen, I have to leave. I'm going through TSA. So I have to leave. I'm going to turn it over to the very capable hands of these fantastic members of staff. Thank you so very much.
Thank you, Mark. Have a good time.
Thank you. Thank you. Bye-bye.
Okay, guys, we are like just cooking with gas here. We are up to number 15.
Can you give, did she do the roll call?
I'm sorry, number 13. I jumped ahead. Or my numbers are wrong. It reads, in calculating the new term to be served by the... No, we already
voted on this.
that.
We
We
are on
voted
15.
on that one. Abigail, we need to get to the victim's rights. Are we missing one? Well, I will read it. All statutory and constitutional rights of victims shall apply to resentencing. The court shall not, in modifying a sentence, disturb any restitution awarded at the original sentence. Obviously, we have a victims' rights statute, we have a victims' rights constitutional amendment. And those would be embedded in this process or procedure. So we didn't really ever talk about this in previous meetings, but I don't think there was ever any doubt that victims' rights would be respected, I'll say. So do we have any discussion?
My question, thank you, Kathy. My one question is it embedded in the constitutional rights of victims to be notified that this person is has actually put forth a petition for resentencing?
Well, it's not specifically because this is a new provision, but I'm seeing two hands, so we might have better experts on this. I don't think it would be excluded by virtue of not being specifically included, but I'm going to go to Kelly first and then Scott.
Hi, I my phone is doing something weird, so hopefully this is working. I do wonder if it would be beneficial to be more explicit about acknowledging all of the rights that are afforded victims via statute and the Constitution, just so that it doesn't go unstated.
Okay, would that be, you want to include all of those rights in the recommendation?
I think we can just make reference to them.
Okay. Are we not doing that with what we have? It says all statutory.
Well, yeah. I mean, I'm trying to respond to the question. So I think maybe saying, shall apply to rights of victims as spelled out in statute and the Constitution, including rights to notice and other things, some generic language to show that is contemplated.
Okay, I see what you're saying.
I think that.
Scott?
Sorry, I probably should have lowered my hands until I had the specific language in front of me. But what I was recalling was in terms of during the push for the constitutional amendment, that part of that was whenever there was a proceeding occurring that could alter a sentence, that was one of the things that triggered the rights of crime victims. So it was like, I don't think any of us would want to do anything that would be, certainly we want to follow the law and follow the constitutional amendment. But I think we just want to make sure our language would agree with that to provide that notification. I don't like they have a right to be participating and be heard at such a hearing. And so I think we would just want to make sure that we are in line with that language. But I believe the Constitutional Bill of Rights language does capture what we would be envisioning through a resentencing process, but I didn't get to the right language yet.
Well, I will tell you the right to timely notification of all court proceedings is section 3 in that amendment. And the right to be heard at any post-arraignment court proceeding, including involving a release decision, is also in there. And the right to be notified of conviction, sentence, imprisonment, and release. So I think we're covered by referencing those two provisions in their entirety generally. But if we want to be more specific, we could say the rights of victims enumerated in the statutory and constitutional provisions shall apply, so it's clear that all of them apply.
Sorry, if that was a question for me, I got bounced out and just got back in.
Yeah, I'm sorry. Kelly, we were looking at the Victims' Rights Amendment, and it does specify the right to notice for all court proceedings. So, and also any release decision. So I think that the language that's already existing covers everything that needs to be covered and would apply to resentencing because it's a court proceeding. So do you want to try and do something more specific in this recommendation? Or is
I don't,
less more?
I don't have to, I'm really of two minds here. I spoke up in response to the original question. But I think that, contemplating our audience, saying just, the statutory and constitutional guarantees leaves open a question in someone's mind as to whether that means that they'll be notified, means that they'll have an opportunity to present testimony, any of those sorts of things. And so I don't want to belabor it, but if the first thing that came up was a question of whether or not, they would be notified, it seems like that would be something that would pop into other people's minds too.
Okay, so perhaps
Shobha.
Yeah, Shobha.
I'm not opposed to including that notice language, but I was also wondering if it might help if it said all statute, because I noted that Lisa was sort of flagging even the filing and just this whole process. And also, so all statutory and constitutional rights of victims shall apply to the resentencing process, perhaps, or the resentencing proceedings. I worry that resentencing is kind of too vague, like when, when and what we're talking about.
Okay, so let's do a little editing here. Abigail put change resentencing to the resentencing process first.
You like procedure better, process, one of the two.
Resentencing procedure, whatever. And we need the before resentencing. And then comma after victims. So we have all statutory and constitutional rights of victims, comma, including the right to notice and to be heard.
Perhaps including but not limited to.
Comma, right, including but not limited to. Shall apply to the resentencing procedure. And then the court shall not, in modifying a sentence, disturb any restitution awarded at the original sentencing. And I would note for the record that Orlando has left and Yakov has joined us just in time for the last couple of recs.
Lisa?
Hi, can I include the entire resentencing procedure? That way there's no misunderstanding that we're talking about from the petition being filed through conclusion, whatever that looks like.
No harm in being a little bit more descriptive.
Cheryl?
Weren't we talking about, didn't we talk initially about giving or the victims having an opportunity to weigh in initially anyway, because we were also talking about some kind of the word escapes me right now, but like a community justice situation where they have the opportunity to speak with each other. Didn't we start from that perspective?
We did include that. Let's see. In one of the recommendations that victims would be informed of any restorative justice. I'm sorry, that was not a recommendation. That was in our principles. That they should be informed of any recent restorative justice processes that were available to them, either through the state or local jurisdictions. And we also had a recommendation, or a principle, I'm sorry, about victim impact statements. So this recommendation would cover the principle that spoke to victim impact statements. And the principle regarding restorative justice would be, it's going to be included in the report, but it's not specifically mentioned in terms of this recommendation. But it is contemplated, I would say, by our previous discussions, that there would be something that's not just the court process, but that would be accessed when a motion was filed, that would allow a restorative justice experience if the victim and the incarcerated person both wanted to do that.
Comment, discussion? Shilda?
I'm not sure if it's necessary since it's in the principles, but if folks want, I mean, we could include it here too, that literally basically the same thing, but it is in our principles, I recall. The victim shall be informed of any restorative justice process that can be made available to them, or some language along those lines. But I'm also okay with it not being here since we have it in the principles, I believe.
So as amended, the recommendation now reads, all statutory and constitutional rights of victims, including but not limited to the right to notice and to be heard, shall apply to the entire resentencing procedure. The court shall not, in modifying a sentence, disturb any restitution awarded at the original sentencing.
And I'm sorry, Orlando, I'd like you, if you don't mind, to share your comment with the group.
Yes, I'm sorry. I just didn't want to leave before this recommendation. I do want to note that Director Yakov will be voting. I was just wondering regarding the process of delivery of that notification. Who would it be? Because I think the who and how that message is delivered or that notification is really important when considering just re-traumatization and who the best person is to actually deliver that message, who may have the best relationship with the crime survivor.
And the message specifically being opportunity for restorative justice.
Yes, and even just the notification that someone may be coming up for a resentencing opportunity or hearing, like how exactly that message will be delivered and just being considerate of the impact of that message or that notification.
I can say that right now, I don't think we do it very well, but I don't have any specific knowledge on that.
I could agree with that.
Lisa, I mean, you have experience with that, so maybe if you could share that briefly.
Just the interaction with the victim, my personal experience with and interacting with the victim witness unit at the state's attorney's office has been horrific for the entire time my son has been gone. So I am in agreement with Orlando that there is that the messenger and how the message is delivered is important. It truly is important. Now, just to re-traumatize victims and survivors of violent crime is only continually perpetuates the cycle of violence in the communities. And if we're not clear on that, we're missing everything, every effort that we put forth to curb violence, to restore justice is thwarted when we re-traumatize victims and survivors.
Chief Mitchell, did you want to weigh in?
You know, I just want to first of all commend the folks who just spoke, but from coming from two differing viewpoints where they originate from. And to piggyback on what they're saying, I think that we need to be intentional on making sure that the voice that our, even though it may be stated in statute and things to that effect, I think we need to be deliberate and intentional on making sure that we are putting verbiage in everything that we do that does ensure that our victims are heard here and that they are dealt with the same amount of time and effort that we're doing for resentencing. We should make sure that we're making sure that they know that it's not just implied, but that they actually know that we are deliberately looking out for their well-beings.
So I'm diverging now from the agenda, but I'm hearing that there's, we've touched on restorative justice in a couple of different meetings, but we haven't included a specific restorative justice recommendation other than the people will be informed of them. So I'm thinking that in order to maybe give this issue its due, that I could include in the report just a brief discussion of the points that have been raised across a variety of meetings around the restorative justice approach and the concerns that all of our members have raised, so that it's covered in the report. It's also in the principles. If we want to add something specific here, we can, but if we don't, there will still be specific information in the report on this topic. Is that an acceptable approach?
That's acceptable for me, Kathy. And what would be even a greater pleasure and honor is if I could work with you on crafting that portion of the report, simply using a survivor's voice.
I have no problem accepting volunteer help. Cheryl, I see your hand.
Okay, yes. So I agree with you on that. Let me just say, I don't think we need it here because it's already somewhere else. And my second statement is going to be that I'm not sure I'd want to limit the portion regarding restitution. I think it's something that should be considered, because if you're going to let them, if we're going to recommend that they have the opportunity to depart from the mandatory sentencing, then they should be able to look at the restitution, only because at one point it was very common for restitution to be hundreds of thousands of dollars. And so while we haven't seen that lately, that was regular practice in Cook County for quite a while. But what I really want to say is, when we talked about restorative justice in the principles early on at the last meeting, I was still trying to actually unmute myself and never had a chance.
Right.
So as it relates to restorative justice, one of the things that I wanted to know, which you can discuss, is at the time that it looks like a person is about to file or when they first file, can there be a way to offer the opportunity for the restorative justice process to the victim and the defendant before it gets to court, so that if there's any quote unquote restorative justice that would work, that they will have had an opportunity to work through that? It's something that I'd like to see, but I don't really know how to have that done in this particular process.
I am going to defer to Lisa and Jacob or Orlando to address how that might work. And if there are any models out there. I think actually I read this was several years ago in Ohio. There was a staff, I think it was through the Department of Corrections, but it might not have been, who actually personally went to contact victims when someone was about to be released, or they might have gotten relief somehow to, one-on-one talk through what was available. But that's the only time that I've ever seen a formal program referenced. Lisa or Orlando or Yakov?
Yeah, this is Yakov. I would add, that's a great suggestion, by the way, and I would add that during that process where prior to the resentencing or when the resentencing forms are initiated and the crime survivor is contacted, that the crime survivor is informed that there's now this Healing Beyond Harm restorative justice program that exists. Here's how, if interested, he or she can have a restorative conferencing with the person that's filing for a resentencing. And I think that would at least begin that process, because the program exists now. It's just that crime survivors are just in the beginning stages of being notified or being aware that this program exists. If that makes sense. Like somehow including it in that notification to the crime survivor that the Healing Beyond Harm program exists, and it's a process that the crime survivor can partake in.
So that would cover the state avenue to the process. And if there were a local jurisdiction avenue as well, the victim could be informed of that. And we would, that would kind of have to be figured out in each local jurisdiction, I would think. But obviously you get a motion to resentence, somebody in the clerk's office or in the judicial constellation would know if there was a restorative justice program available, I would think.
And this is Orlando speaking, and I definitely agree with that, Kathy. The system currently doesn't exist, but the only input that I would have is to keep this as closely as possible, aligned with community and community stakeholders. If there's a process that doesn't exist, how do we empower restorative justice centered community-based organizations to do the work? And how do we support those community-based organizations to actually create the work? There is an idea, and we're looking at how to develop that out, offered by Father Kelly at Precious Blood, where similar to first responders, there would be a team that could be deployed in support of crime survivors when something like this is identified. We're looking to adopt that that model in some way for the Healing Beyond Harm restorative justice pilot. But I think because this work will be centered in Cook County, it'll be I think, I don't want to say easier, but it'll be not so much of a heavy lift if we build it out intentionally. If, again, we support those community-based leaders and stakeholders to be able to do the work, and not just those that work for organizations, but also family members and directly impacted people of harm to do this work that are interested in doing this work.
Chief Davis?
And I'm trying not to be redundant, but just hearing such great commentary. I think to take it a little bit further than just being intentional, that at some point, whether it be in our attached notes or our overall recommendations, not these specifics, but that we one of the things that we put is that there be a parallel process directed at victims or resources, things, and once again, being intentional and direct on just ensuring, but actually saying that there's just like we're going through this, that there's a parallel process being developed to make sure that we address the concerns of our victims. Thanks.
Okay, so I think the question right now is, do we want to add reference specifically to restorative justice in this recommendation. And I think it would go right before the last sentence if we do. Just add a line that the victim shall be notified of any restorative justice programs available at the time the motion is filed.
Comments, discussion.
Did we already put in there did we already address the concern about the actual notification of the filing, or did I miss that? Should that be put in there as well, or did we address that earlier? I can't remember.
Well, I think if it's referenced here, it's a guide for the General Assembly to address notification. So that what's contemplated by, I think, Orlando or Yaco's comment was when there's a notice that a motion has been filed, that notice of restorative justice will also be included. And going to Cheryl's point, the process, there'll have to be some process details worked out to allow that process to work out before the motion to resentence is considered. Shobha?
I think so. I think yes, the answer was we did include the notice references. I think that's what the chief was asking about in here. And then I just had a clarifying point. Was Judge Ingram proposing a modification on the restitution piece, or is that remaining?
Oh, yes, thank you.
Yes, I think, yeah, I am proposing a modification, and I would propose that it read like our last recommendation, that the court, and I don't have it in front of me, may be able to modify the restitution award. The same language we had in the last recommendation as it related to the sentencing.
So the court should have the authority to modify any restitution awarded?
Yes.
I'm sorry, wait a minute. I'm raising my hand.
Lisa?
I'd like to get a little more clarity around why, just a little more clarity around that, Judge Ingram. Help me understand why you feel that if I'm hearing what you're saying, you're saying that the court should be able to modify, I'm sorry, that the court should be able to disturb the restitution awarded at the original sentence if the sentence is modified?
Okay, so what I'm saying is that I think in the last recommendation, we indicated that the court should be able to modify the sentence. And I'm also saying that the court should be able to modify the restitution award. And I'm not saying that from a perspective that the victim should not receive any restitution, but the reason I'm saying it is because there was a practice, not as much now, but there was a practice in Cook County at one point where sentences would include restitution like millions of dollars or hundreds of thousands of dollars. And so you really realistically talking about someone coming out of prison and going to pay that. It'll be great if they win the lottery or they get, the rich uncle dies. But the reality of that is unrealistic for someone who's trying to get a job with a criminal background. So at the time when judges were doing that, it would just be some outrageous amount that was just unrealistic in terms of the criminal justice system itself. I mean, this isn't a civil court. And so I think if you're going to give the court the opportunity to modify a sentence, you should give them the opportunity to modify the restitution. Not that it's mandatory, they don't have to, but they should have the same opportunity. If you're modifying the sentence, restitution is a part of that as well, is a part of the sentence. I don't disagree.
Thank you, Judge. I understand now.
So Judge Ingram, you're suggesting language changes.
Or just a deletion of the prohibition?
Well, you can delete the prohibition, but since we've already moved past the last recommendation, I think in this particular instance, just delete it. Because I think when we gave the court the opportunity to modify the sentence, I think restitution is a part of the sentence.
Okay.
Comment, discussion?
Okay, our revised recommendation reads, all statutory and constitutional rights of victims, including but not limited to the right to notice and to be heard, shall apply to the entire resentencing procedure. The victim shall be notified of any restorative justice programs available at the time the motion is filed. Do you want to, Carol, do you want to add something about completing if possible, or something about the court shall, make it clear that the restorative justice process should be given a chance to work before the motion is disposed of? Do you want to add something specific along those lines?
I'm not, my thought about the restorative justice, I don't know if it needs to be in here, but I think the fact that it's offered as soon as the motion is filed is sufficient for now, but in my mind, it needs to be probably sooner, but definitely at the time the motion is filed. If you say to give it a chance to work, then it's too arbitrary in terms of time, I think.
Okay. Well, if the pilot in DOC works as intended, victims will get notified now that there is such a process.
Right.
Some of them will go through it.
Right. Then the earlier they're notified, the better. And long before the motion is filed, really is I think would be best.
Right. Okay, and there's a comment actually, Shobha, thank you for your comment. We have skipped back and forth, and I was going to ask for a decision on this, referring to a petition and referring to a motion. Let's decide what we want to call it so that the report is consistent throughout. If we use petitioner, then the person filing is the petitioner. I see one vote for petition. So what do we think, folks? Change motion to petition throughout our report and our references.
So moved.
Is there any objection to changing motion to petition? Okay, I'm seeing agreement.
Hearing none, maybe we can move on and either take a vote on 15 or note the time. We're losing people at noon. We have lost some already.
I move we adopt as amended.
Do we have a second?
I'll second.
Okay, so here we go. Kelly?
Yes.
Closing comments.
Robert Peters?
Yes.
Ari Jones?
Yes.
Scott Main?
Yes, with a hope that in the comments in the discussion that a lot of everything that we've talked about is captured in the report's discussion, including Lisa's point regarding who is delivering the information. I think it's important for us to be thinking about that. So I think that's just an important thing to keep centered.
All of that will be in a dedicated restorative justice section. All right, Sharon, are you with us? I don't think Sharon ever came back. LaToya Hughes?
I am present. Yes.
Okay. Lisa Daniels?
Yes.
Joby Cates?
Yes.
Yakov Delaney?
Kathy, I'm here. I was trying to get off mute before the motion was called. I have sort of an issue with the language of victims being used in the same context where we're using restorative justice principles, because we're moving away from like harmful language, and we think even using the term victim is harmful. So, and I know I heard you just mention that there's going to be a whole restorative justice section, so maybe that can go in there, like victims / crime survivors. But yeah, I just wanted to add that in there, that I think something that crime survivors should be added to here, maybe victims / crime survivors.
Okay.
Shoba, I see your comment as well.
Yeah, just to support what Yaakov was saying in terms of the survivor language, which I know has become more prevalent, and just I'm yes otherwise, and just to chime in on the comments that have said about centering the delivery around community of notice and support of survivors and victim family
And my
members.
vote is yes if I didn't say that.
Okay, thank you, Yakov. Chief Davis had to leave. Shoba?
Oh, sorry, that was a yes.
And Cheryl?
Yes.
All right, we have unanimous support for recommendation number 15. I would note that we have 2 recommendations left to consider: the right to appeal and data reporting, which I imagine will be very quick. I know we talked about adjourning at noon, but if we get through these 2, we don't have to have our meeting on the 30th, maybe, unless something comes up of major import on the 29th at the public hearing. So, shall we plow ahead, even though we lost 4 members?
Those of you who wish to plow ahead, raise your hands, please. Okay. Moving on to recommendation 16.
All right. Recommendation 16, the petitioner may appeal a final order from a resentencing proceeding. This is where we were getting at the actual disposition of the motion is an appealable order. Do we have any discussion on that one? We've touched on it a lot of different times in a lot of different meetings.
Move to pass, please.
Second.
All right. Kelly?
I don't know why I keep muting myself as soon as I hit second. That's really dumb. Yes.
Robert?
Yes.
Ari?
No.
Scott Main?
Yes.
Sharon? LaToya?
Abstain.
Lisa?
Abstain.
Joby?
Yes.
Yakov?
Yes.
Shoba?
Yes.
Cheryl?
I'm sorry, you're asking me to vote on it as it's written, correct?
Yes.
No.
All right, we have We have 6 yeses, 2 nays, 2 abstentions. We have 10 people voting, which So the motion, the recommendation is passed. Last recommendation is appropriate data must be collected and reported. We got very general with this because SPAC is going to work on some appropriate language to ensure that at some point in the future, we can issue a substantive report on the impact of resentencing. But at this point, we were in favor of a more general recommendation. So is there any discussion on number 17?
Motion to pass, please.
All right, do we have a second? Oh,
Second.
wait, Latoya, I see your hand.
Hi, I'm just curious as to, is this specific to SPAC or is this specific to?
Well,
It's just so general. I'm not sure who's being asked to.
Well, first of all, DOC has great data reporting from our perspective, so don't worry. No, I mean, this would be data that has to be collected from the court system to allow an analysis of resentencing. So we will, it's this, I don't think we can get into the specifics.
Okay.
And it will be appropriate based on research needs as well as operational administrative needs. Most of the time we ask for a lot more data to be reported than is actually relevant. So we're going to try and work, and whoever wants to join that conversation, obviously, our door is always open.
Thank you for those considerations.
Are there any other comments? All right, do we have Robert, you moved? Is that correct, to accept this recommendation?
That is correct.
Do we have a second?
I seconded it.
Okay. Last roll call of the day, folks. Kelly?
Yes.
Robert?
Yes.
Ari?
Yes.
Scott?
Yes.
Sharon? I think you're not with us. Latoya?
Yes.
Lisa?
Yes.
Joby?
Yes.
Yakov?
Yes.
Joba?
Yes.
Cheryl?
Yes.
All right, members of the resentencing task force. We've had a robust day. We've come to the end of our agenda, except for, is there any public comment? I don't know. I think we have maybe one person, a couple of people from the public. So it's now 12:13. Our agenda allowed for public comment at 12:30. I will stay on with the meeting open until that time. But Lisa, why don't you wrap it up with us?
Yeah, so we had a robust, no, mute Susan. A robust day of considering and then accepting recommendations to put forward in the report. Do people have kind of closing thoughts in terms of your hopes for what will have kind of a big impact or kind of concerns about how this works moving forward? Scott?
I just wanted to speak real quick with expressing gratitude to Lisa Daniels and Yakov, anyone who's willing to put forth their energy into a good and full conversation about restorative justice within this report, I think is critical. And I think I am very grateful for your willingness to take on that responsibility. So I am just wanted to speak in deep appreciation.
Great. I'm sorry. Joby. Mute.
I think Latoya Hughes was online before me. Latoya, do you want to go first?
No, go ahead, Joby. Thank you.
You know, I want to echo my thanks as well. I know this is actually
Other reflections?
This is a hard, I'm sorry. Can you guys hear me?
Yeah.
Joby, you're on mute.
Oh, okay.
No,
No.
Joby's not on
Everyone
mute.
can hear me
Can hear
except
her.
you, Lisa.
Joby, you're still on mute.
Lisa, she's not on mute. Everybody else can hear her.
Oh, I'm on mute.
So, Lisa can't
That
hear me.
means
I'm
can't hear
sorry.
any of us.
I can hear you. Okay, I'm just going to go ahead. A couple of things. One is, it occurred to me after our last meeting how much has changed in the past 10 years since Miller v. Alabama was decided and those first resentencing started. And I'm not going to give you a huge speech, but I really want to recognize that all of the members of law enforcement who are part of this conversation today, even when we don't agree and when we vote different ways, I think the level of engagement and thoughtfulness that everyone is bringing to bear on issues where we maybe don't agree it's unprecedented. And in really close to 15 years of doing this work, and particularly in the 10 since Miller, just the fact that we're having this public and documented conversation together it represents an enormous amount of progress. I know it doesn't always feel that way on either extreme end of our debates. But when I step back and look at the complete lack of engagement 10 years ago, right after Miller, or inability to have the simplest conversations about these issues, I just want to recognize everyone in this community for stepping up and how different this community is today than it was 10 years ago. So thank you all.
Latoya?
And if I am next, I just wanted to say my comments are really surrounded about or around just providing context to the extent that we can to some of the recommendations. Specifically, I had some technical difficulties earlier, and specifically regarding number 6 as it relates to the department providing notice. I know that recommendation has already passed, but again, just for context, as we write out the report, building that out as to what that actually means. If we want a process that is going to actively work and be effective and efficient, we really need to think through what some of these things mean, because just putting in a statement that someone is supposed to do something, we all know that things do not generally work out that way, and we really have to think through everyone's abilities to do so. And so I just wanted to kind of put that on the radar, and that's kind of the comments for me. Thank you.
Thank you. Shoma?
Just real quick, I just wanted to also express gratitude to everyone here, especially those who represent the voices of those most impacted by what we are talking about here. It is, it might be a theoretical or even close to the heart exercise for some of us, but it has real and concrete meaning to some of you who feel this every day as the human beings and the full human beings you are, and I'm grateful for your voices. I know these are sometimes hard conversations. Also, just wanted to dovetail on some of what's been said, which is that I realize this is not the end of a conversation. It is something of a beginning of a conversation, and one, as we've talked about, that's long overdue in this state. But I hope that what we've done here or started to do will really open up some possibilities for our General Assembly. And I think that's really important that we have provided them with some guidance and context and principle. So I'm grateful to really all of you and to the staff. Thank you.
Anyone else? Okay. Thank you all for your thoughts, those who wanted to share. Kathy, from a procedural point of view, it's 12:19.
Actually, there's one other thing that I want to let our members know about, and I will do an email. I don't know that all of you may not be aware that Latoya Hughes is now the Chief of Staff at the Department of Corrections. So, yay, Latoya, on that. But
thank you.
she has been helping SPAC with arrangements for our next SPAC meeting, which is going to take place at Sheridan Correctional Facility. We cannot invite you to join us personally, but it will be on WebEx. You can find a link on our website and that is a week from today. And we meet from 10 to 1 if you would like to join us virtually. I think we're going to be talking to some folks who are serving sentences for gun crimes. So it might be useful to you to hear what they have to say, as well as DOC staff. So I think the only other question is, please, as Susan noted, let us know if you can come to the public hearing virtual, 100% virtual. We hope that you will blast out the hearing, the public notice hearing that you got in the materials for this meeting to whatever distribution list that you have. And, we're putting together a couple of invited witnesses to fill in some of the gaps in what we had at this process. But at this point, I think we can agree to, Scott has raised his hand.
Well, I was going to move to close, but do we have to do anything more than if we had already previously responded to Michael's invitation? Is more needed for the public hearing? Okay. I move to adjourn.
And so I think with that, the only question for the members is, do we want to keep our September 30th meeting on your calendars just in case? It would obviously not be a 4-hour meeting. Or do you want to go ahead and take that off of your respective decks of things to think about? Let's do what Susan did. All those who are in favor of keeping it on your calendars just in case, raise your hands. Scott, you're the only one.
No, Lisa.
Lisa was with me.
Oh, okay. Well, at this point, we will confirm that the meeting is canceled after we, oh God, there's Jody. So maybe we have a meeting.
I actually I have a question.
Yeah.
I wasn't voting so much as I have a question, which is, Kathy, would you like some of us to stay on with you for 12:30 so you're not sitting here all by yourself?
Well, if you want to, I mean, it's only 8 minutes away.
I just figured, and I would listen to public comment if there is any too. And if any other members want to join, it might be nice so poor Kathy isn't hung out here all by herself.
The only reason I voted in favor of keeping the meeting on the calendar is just, we have not had public comment really up until this point. And if we do, I would like the task force to be responsive, and maybe we can just do that via Kathy, you summarizing, or the participants summarizing out to the task force members about what we receive. I mean, I think we've put in the time on these recommendations, so I don't want to meet for the sake of meeting. I just think that if we are getting response from the community, that we take the time to have some conversation about it. It doesn't necessarily have to be via a Zoom public meeting. And so I'm well in favor of not having a 4-hour meeting that Friday. But I just want to make sure that we are in a responsive posture if people do participate on that Thursday.
How about, I will suggest this. Number one, we will go ahead and publish the full list of the recommendations that have been voted on and adopted by the task force on our website, and ask so that people who come to the public hearing have the ability to respond to them and comment on specific ones if they so choose. What if we keep an hour of time on the 30th for us to recap the public hearing for members who aren't able to be there? If y'all come to the public hearing, then we don't have to do it. But I don't think everybody was able to join us for that. The public hearing is only 2 hours. It's from 9 to 11 on Thursday, the 29th. So should we keep an hour of meeting time? all in favor of keeping an hour of meeting time on the 30th? Raise your hands. I see a Cove. Joby. We've already lost some of our members. Latoya, what about you?
I could go either way. Whatever the committee decides, I'm fine with.
Okay. Cheryl, do you have a feeling one way or the other?
Not really. I don't know that we need an hour, but
All right, well, pencil it in. And Shobha, did you have something you want to say? Because your hand's still up. Okay. All right. Well, then I think I will, it's 12:26. Do we have any public comment? Okay, Cheryl, I see your hand up. Is that?
just a question. We'll get notice for how to zoom in for that public meeting, right?
You already did.
For the 29th?
We
Yep. All
yeah,
meetings have been sent out. All Zoom information should be in the calendar invite that you've already received.
All right.
and it also
just-
is also posted on the SPAC website. And I will say, we have not gotten any notification. We have one notification from a member of the public intending to speak. So it may turn out to be a shorter hearing, but you know, it's still pretty far out. I wouldn't anticipate that people would have necessarily registered. So, all right, well, public comment, we will open the floor. I'm looking at the screen. I see one member who I think is a staff person. All right. It would appear we have no public comment. So is there a motion to adjourn?
So moved.
Do we have a second?
Second.
All right. This is one I do not have to take a roll call on. So thank you all for getting us through these recommendations. Thank you so much.
Thank you, Kathy. Thanks everyone on staff for all their hard work.